refined as broadly accepted customs, clarified and exampled through commentaries like Vigyaneshwar Mitraker and Jitubhan's Dayabhaga, which together gave rise to two great schools of Hindu law. Law in India was never static. While Mitraker school based inheritance and blood ties, Dayabhaga school maintained that succession rested on the right to perform the Sadar. Dayabhaga law basically related to Bengal and Assam. So the divergence arose from single Sanskrit word Pinda, a sloka in the chapter 9 of Manusmriti declares that upon a man's death, his inheritance shall pass to his nearest Sapinda. The integration of Sapinda, however, hinges on the meaning ascribed to the word Pinda. The very pursuit of meaning became crucial, in which the great science of interpretation, such as Mimamsa Sutras of Jaimuni, Jaimuni and was posed. Our sages developed rigorous tools of interpretation to resolve the loopholes and gaps in law, such as courts today interpret statutes to make unforeseen situations. In addition to laws governing family structures, the remnants of ancient Indian laws are reflected in administrative and judicial structure that hold them Dharma Shastra like Brihaspati Smriti and Narada Smriti. The ruler was enjoined by the sacred text to uphold Raja Dharma, a structured system for the appointment of a bench of 5 magistrates as laid down in Jatakas. Judges were to be learned, righteous, calm and as impartial as possible. Vishnu Smriti prescribed banishment and forfeiture of property for those guilty of corruption or injustice. Similarly, Kautilya Arthashastra recommends one court for every 10 villages, with higher courts established for Janapadas and provinces. Interestingly, Janapada still forms the basis of the revenue and administration in India, with a BDO rank personnel in charge as CEO Janpad, as the states like Madhya Pradesh and Chhattisgarh. From the Smritis to the Constitution, our forefathers gave us more than rules. They gave us a methodology to interpret, to adopt, and to remain anchored in justice while navigating the change. So, in studying our past, we gain not only the historical insight but a living guide, and remember that while the forms of law transfer with each era, its ultimate aim remains eternal, to secure fairness, order and well-being of all. I do not wish to impede upon the valuable times of their lordships. My lord, both of them are exceptional speakers with profound knowledge. With that, let's proceed with this lecture in honor of the cherished memory of late Jena. On behalf of the Bar Association, we extend my heartfelt gratitude to all dignitaries and attendees for their august presence. Thank you.
Thank you, sir, for your insightful words. May I now request our guest of honor, Honorable Shri Justice V. Narsingh, to kindly address the august gathering.
Good afternoon. Samasto Kumar Vinamra Pranam. Master of the Ceremony, Mr. Tripathi, esteemed President, revered Chief Speaker, let me make an honest confession. Sharing the podium with him is in itself a great honor. At the outset, I pay my deepest homage to the departed soul, GAURANGA BEHARI JENA, with whom I had the good fortune of spending not less than 2 decades at the bar, and esteemed senior counsels are there. My brother judges, Justice Mruganko and Justice Sanjay Mishra are here. They all know that that is the only qualification which earned me the space this side of the mic. Otherwise, I am not even qualified to speak about the GAURANGA Bhai. Gauranga Bhai was a human being of excellence. That would be stating the obvious. As the master of the ceremony had said, he had many facets to himself. A man who loved to sit cross-legged but always talked straight. A man was, he had many elements. He was as my friend Mr. Tripathi said, he was a stamp collector, he was a coin collector. Incidentally, that word numismatics I discovered only today. So in common parlance, we can say he was a stamp collector and coin collector. That makes our life much easier. There was a common bond between us. That was newspaper and books. I have this good bad habit of carrying a newspaper with me, which I still do today. So he was a subscriber of a different newspaper. I carried another newspaper. I am not taking the name lest I will be guilty of propagating a particular newspaper. Tomorrow they will say there is a conflict of interest. So my bond with Mr. Jena was, as I said, books and more particularly autobiographies. We loved autobiographies. We shared many books, whether it is Nani Palkiwala's We the People or VVS Lakshman's 281 and beyond. We read both the books with equal vigor, and our discussions were much beyond, law and much beyond it. As a lawyer, I was telling Dikshit sir, he had the blessings of both clarity and brevity. Always a man there to help anyone who seeks his help. For one, I can share with this august audience, I got my drafts corrected many a times by him. I requested him and he obliged. I got my writ petitions corrected. I got my claim statements and written statements in arbitration matters got corrected by him. And he was such a gem of a person, he will never say that I have committed a mistake. With his usual charm, he will say, probably this expression would convey the idea which you wanted to convey. That was man Gauranga Behari Jena. And friends, it's very actually difficult for me to stand here and speak because of my long association with him. I had promised Sujatappa that I will rein in my emotions. So that's what I'm trying very hard to do. I do not know how long I will be able to do that. As a lawyer, he firmly believed in the Austinian concept that law and morality are overlapping circles. And I must, my salutations to the family that they have chosen a topic of a memorial lecture, that is ancient law in India, because I think the concept had its moorings in the ancient laws that we have chosen. And without the fear of contradiction, I can say with all humility at my command, we could not have chosen a better speaker than Justice Shripad to speak on the subject. So with these words, I take leave of you. Thank you all of you for giving me the opportunity, particularly the family of Gauranga Behari Jena, Sujatappa, his son, Buttu, Sanjay Das, and the entire family. If I start taking names, we will be delaying the lecture for which all we have gathered here. Thank you so much, and I am really grateful to the organizers. Thank you. Jai Hind, Vande Utkaram.
Thank you so much, sir, for your thoughtful words. Now it's the time that I may now request our chief guest and speaker, Honorable Sri Justice Dikshit Krishna Shripad sir, to kindly come on the podium to give his lecture on the topic of ancient laws. Please, sir.
A lawyer has a right to lie. And Mishra Saab, being a leader of the lawyers, has a larger right to lie. He described me as a jurist. Very happy to hear. But falsehood also gives happiness. So with that caveat I have to start. It's a great gathering in the evening of Sunday. And when I was about to start my lecture, you all clapped. When claps happen before commencement of the speech, it is a warning to the speaker that don't be too long. They are justified in that, in alerting that way. Bar should alert the pitch. My esteemed brother Nursing, jubilant brother, also lied. But a judge has no right to lie. He can pretend to speak truth, but he cannot lie. He also shared the same wrong view which Mishra Sahib had. Anyway, there is one famous shloka. I do not know from which it is chosen. It says, Satyam bruyat priyam bruyat na bruyat satyam apriyam non-rutam. If you want to tell the truth, tell that truth which is beneficial, benevolent, and don't tell the truth which is malevolent. But don't lie also, non-rutam. It is some, I do not know, maybe it is from some Upanishad. It cannot be a matter of some Smrutikaras like Jaimini, which Mishra Sahib mentioned. Where from I should begin, I do not know. First, I should confess that Madam Jena issued writ of mandamus that he should come and speak, and violating such writs, although they are considered a bit lenient in Orissa High Court, but man coming from Karnataka High Court is afraid of violating the writs. I am afraid of contempt. Therefore, there is one provision in erstwhile CRPC. Accused appearing before the court on his own. Accused being brought before the court by police. I chose the first option. And that is how I am here. I am very happy. My closest friend Sanjay is here. And my distinguished friend Murganki is here. My jubilant friend Nursing Sahib. And your most popular leader of the bar, Mishra. And the master is just watching me as to what I am doing. Topic is bit large. We have three classes of people. One, those who want to hear about Ganga Snan, Tunga Pan. They hear, they feel very happy. There is other class which is not that happy with just hearing. It wants to go and witness the flow of Gangetic waters. And yet another class would dip into Gangetic waters and say, Ma Ganga, my pap is washed away. There is a small class of pilgrims. They will not be happy either by hearing about Ganga or witnessing Ganga's great flow or even dipping into Ganga, but they want to go to Gangotri. They will walk. And a smaller section of pilgrims, they will go to the epicenter of Ganga, Gomukh. So where the river took birth, the great river which Bhagiratha brought, that gives a sense of satisfaction. Similarly, to know law, we should go back in history where actually law takes birth. From society to society, peoples to peoples, geographies to geographies. it changes. You have seen the Roman law by Livy. Roman law took birth from the emperors. Islamic law took birth from the days of Prophet, Quran, Hadith. English law is traceable to Roman law. This is what Francis Bacon, the Lord Chancellor, said. Lord Edward Coke said, if you see the standard books on legal history of England by Jackson, Machinery of Justice, he writes like this. But even Austinian notion of law, which brothers were mentioning, he defined law as the command of sovereign enforceable by sanction. Many critics are there. From the days of Aristotle, the effort to define law has ended in vain because law eludes the definition. There can be explanation. When Austin said, law is a command of sovereign, enforceable sanction. It requires minimum amount of social mass to habitually obey the law. So habitual element is there. It is law, therefore you should obey it. There are many critics of Austin. Julius Stone, Lloyd, they do not fully agree, they criticize. Then the author of Pure Theory of Law, he also is not that Kelsonian pure theory of law. Kelson. He much criticized the notion of law of Austin. Then Oliver Wendell Holmes, the US Supreme Court judge, a great judge. He himself was the author of many books. One of them is Common Law. He was also critical of Austin. Whatever that be, we can roughly understand law as a code containing the norms which bulk of the society habitually or because of fear of sanction would follow in their interaction, in their intercourse. So, taking that into account, I begin my topic. Law is not defined in any of our scriptures. We did not depend much upon the law coming from the kings at all. Kings also had edicted. There was a body of constitutional law. There was body of family law. There was body of public law. And law for us was more like dharma. Not just religion. Religion is one facet of dharma. There are at least 3 judgments of the apex court where the difference is drawn between dharma in Hindu philosophy, Hindu way of life, from the religion of Westerners. Because it arose under the provisions of Representation of People Act 1951, where soliciting votes in the name of religion is proscribed. It is a ground for invalidating the election of a returned candidate under the provisions of Representation Act 1951. There is another 1950 Act also. We are not concerned with that. Dharma, the apex court itself confessed, very difficult to define. It only said it is a broad way of life, as contradistinguished from the religion the way with which we connect to the Lord, to the cosmos. That is the difference between dharma and law, the realism. Much of, I repeat, much of law in this country, in this subcontinent, emanated from the scriptures. Basically, we have Shrutis, Smrutis and Achara. Shruti, ordinarily 4 Vedas, Rigveda, Yajurveda, Atharva Veda, Sama Veda, 4 Vedas. Then Vedanta, some authors treat Vedanta as part of Shruti. Others treat Vedanta as part of Smruti. Shruti is something which is revealed to the seers, sages on the mountain, like Moses on the mountain, like the 12 commandments which you will read in the testaments. The sages heard, from whom we do not know. They do not say from whom they heard it. Those history of Dharma Shastras, the great author of history of Dharma Shastras, Purushottama Vamana Kane, a Bharata Ratna winner of Dr. Radhakrishnan era, he says even the real Shruti, Smruti, the differentiation is not that easy. The Upanishads, there are 108 Upanishads that have been discovered as yet. There may be more also. 4 Vedas, 108 Upanishads. They you may classify as Shrutis. Then we come to Smrutis. Smrutis are generally commentaries. Brother Mishra was mentioning Yajnavalkya Smruti. Yajnavalkya wrote the Smrutis. One very important thing you have to keep in mind, we have to keep in mind is, we did not have printing facility. Without printing facility, without paper, lakhs of shlokas came from mouth to mouth, from persons to person, from generation to generations. That itself is a mesmerizing factor. Like Frederick Max Muller said, impossible to believe, but we have to believe. Sir Williams said something which the human history should be proud of. Just hearing, no print at all. Where was the printing machine about 500-600 years ago? There was no printing machine. Even script took birth very, very late. This is what the author of Sapiens, Harari, writes. The writing started very late. There was no script at all. There was only Shabda, Brahma, only sound. Sound that makes sense is a word. We call it as a Shabda, not just Ahat in Hindi. Shabda means sound coupled with meaning, coupled with which conveys sense. So, there were many Smrutikaras. Mishra Sahib was saying Yajnavalkya Smruti. Yajnavalkya Smruti was prepared by sage Yajnavalkya. It is said that he was there during the period of Virata, King Virata. Whatever that be, he has laid down a set of principles as to how people should interact with each other. The commentary of Vijnaneshwara on Yajnavalkya Smruti that became Mitakshara. Mita, Akshara. Mita, limited. Akshara, which is not exhaustible, but letters also. Akshara, which will not have Kshara. Mita, Akshara, Mitakshara. Savarna Dirgha Sandhi. That is how Mitakshara took birth. And the author of Mitakshara, Vijnaneshwara, is from my state. He is from Gulbarga. There is a Mitakshara, Vijnaneshwara trust also. I happen to be one of the members of that trust. Justice Ramajais himself being the founder president of that trust. As I said, the king in India used to have the advisors, and whatever these advisors would say used to be implemented. And in the course of time, these repeated implementations took the shape of law. There was no codified law as such, unlike in the case of Romans. No codification as such. We used to draw much of law from Shrutis and Smritis. Many Smritis are there. Manusmriti is there. Many of Smritikaras have given the principles. 2 examples I will give from Manusmriti. Manu said, Pita rakshati kaumare, Bharta rakshati yavvane, Rakshanti sthavire putra. Pita rakshati kaumare, kumari. Who should look after the daughter? Young, little, charming daughter is looked after by Pita, father. Bharta rakshati yavvane. Yavvana. You used to say Javvane, something like that. During the youth, it is the husband who should look after the wife. Then at the evening of her life, it is the son. Rakshanti sthavire putra. Sthavira means old age. Putra will look after the age. This is how, and this became the Article Section 125 of your CRPC. Macaulay recognized that. That was there, even under the oldest code. We always prescribed norms like this. The second example I am giving you from Manusmriti. There are some obnoxious shlokas in Manusmriti. I am not on that. They are there in every scripture. No scripture is exception to that. Offense of theft. You have seen the definition of theft given by the first chairman of Law Commission, Mr. Lord Macaulay. You have seen the definition of theft. Theft is punishable with a particular period of imprisonment, fine, or both, depending upon the worth of the article stolen. Manusmriti prescribes it is the duty of the king to trace the thief and the thieved article, both. In the offense of theft, once he is tried and convicted and sentenced, the theft law comes to an end. If goods are found, you may move an application under 451 of CRPC during the trial, 457 of CRPC, post conviction, post acquittal, whatever it may be, for the return of the article. It may be returned, may not be returned. That is irrelevant for convicting that person. He will be convicted. But in Manusmriti, he said it is the duty of the king to trace the criminal and punish him and restore the stolen goods to the owner, the lawful holder of the goods. This is second one. The third one, Manu says, Yatra naryastu pujyante tatra ramante devataha. See what great loss William called the Code of Manu. And Manu's statues are established in various countries as the first lawgiver. Such a great man. He said, Yatra naryastu pujyante ramante tatra devata. Where women are respected, there the gods will dwell. Compare this with the Western idea of womanhood. The wife in our system is called Ardhangini. Without wife we are incomplete. And in all samskaras, Shodasha samskaras, you cannot perform them without having the wife, mother, daughter, sister. Any one of them must be beside. Your Pandit will tell you, you alone cannot do. Only Shraddha you can do. But these things you cannot, samskaras you cannot do. So much importance is given to women in our, so by our smutikaras. Let us go to comparative jurisdictions. In England, there were 7 witch hunt acts from 13th century to 20th century. If it is shown that a lady is suspected reasonably that she has perpetrated some witch activity, witch acts, witchery, she was liable to be stoned to death. And the last of the Witch Hunt Act came to be repealed in September 1951. How many lives of women are lost? Stoning to death. Can you show one such thing that happens in any of our scriptures? I will not tell about other scriptures. There is another scripture of other faith which prescribes stoning to death for the offense of adultery. How Gautama treated Ahalya, on that ground, you all know. Ahalya is one of Pativratas for us. And she rose back to life after Rama had put his foot on the rock form of Ahalya. In Ramayana you all see. In England, till 1891, killing of wife was considered to be half suicide. It was not offense of manslaughter. They call it a 299, 300 with murder. They call it as manslaughter. Therefore, in Kenny's outlines of criminal law, you will not see the word murder at all. You will say manslaughter. And the punishment was paltry because husband has killed half of himself. That's all. In our system, it was not like that. The women were held in the highest esteem. In the great debate of 7th century between Adi Shankaracharya and Mandana Mishra, who was the judge? Judge was Ubhaya Bharati, the wife of Mandana Mishra, who was sitting for debate with the opponent Shankara. And wife, after so many days of debate, a judge, and she gave verdict against the husband, Mandana Mishra. and said, "You are at fault." And Shankara has emerged victorious. Then, as per the terms of debate, Mandana Mishra embraced Sanatana Dharma and became the first CAM of Sringeri Mutt in Karnataka, Sureshwarananda. This is how the rules were just derived from the pith and substance of our scriptures. Then inheritance of property, payment of ancestors' debt. How beautifully Gautama Sutra mentions. If son has inherited the property of the father, he is liable to pay entire debt. The grandson is liable to pay 1/2 of the debt. The great grandson 1/4 of the debt. And the next progeny, is not liable to pay any debt at all. There is one proviso. If the father has made contracted debts for avyavaharika, then son is not liable to pay back the debt at all. It is the lookout of the lender. This is how our law was. We will go to constitutional law now. There were constitutional laws even before the enactment of our conventional constitution in 1949-50. We have enacted the constitution. In fact, Palkiwala, in at least 2 decisions. One is I.C. Goraknath versus State of Punjab, 1965 judgment, and Keswananda, 1973 judgment, had argued there were constitutional laws before we enacted the constitution in this country. There were Government of India Act 1935, Government of India Act 1919, Government of India Act 1909. It does not stop there. We had a constitutional law right from the days of Ramayana, Mahabharata, Bhagavata. You have seen Valmiki, a man belonging to, perhaps in your state, scheduled caste. In our state, he is a scheduled tribe. Anyway, he comes from the lowest strata of the society. He writes Ramayana. And we put Ramayana on our head. And he wrote Ramayana in Anustuk Chandas. He writes, when Rama's coronation was taking place, Vasishtha, Vamadeva, standing behind, they were blessing Rama. Rama was saying, I have been coronated now. I am the emperor of this world. I am not answerable to anybody. See what power does with man. Power corrupts, and absolute power corrupts absolutely. That happened when he said, I am not answerable to anyone. Then Vasishtha and Ramadeva had held Dharmadanda in their hands. They had patted on the head of Rama, saying, Rama, howsoever high you may be as an emperor, but Dharma is above you. Law is above you. That becomes Dicey's concept of rule of law. A.V. Dicey's concept of rule of law. Just compare this to our Ramayana version. This is how our law was. And mediation, arbitration, you are saying they are of nascent origin. During Mahabharata war, there was mediation between Kauravas and Pandavas, the mediator being Lord Krishna, other for Lord Jagannatha. the mediation failed, leading to the war. We had Raja Dharma, which Kallana of Kashmir, he has written Raja Tarangi. He gives 17 constitutional principles as to the governance. Raja Tarangini is one considered to be, you can see it from Google also, is considered to be the ancient law of constitution. Justice Rama Joyce had written several books, and one book is the Legal and Constitutional History of India, where he refers to Kallana's Raja Tarangini. In Raja Tarangini, Kallana says the king should treat his subjects as children. See that? He should treat the subjects as children. He should take extra care of downtrodden communities. You are speaking of upliftment of downtrodden community under articles of the provisions of the Constitution, 348, something like that. Article 15, Article 16, they have seen. But that was there in Kallana's Raja Tarangi. You have seen what Rama did in Ramayana. I said, Shruti, 4 Vedas, 108 Upanishads, then Smriti, we have Narada Smriti, Yoga Vasishta, Gautama Sutra, Manu Smriti, Parashara Smriti, Manu Tika. Okay, we have many Smritis. Smriti in Sanskrit is called memory. In Bhagavad Gita there is one shloka. Smriti Bhramshat Buddhinasho, Buddhinashat Pranashyati. If your memory fails, your intellectual prowess weakens, and that will be prelude to your fall. Therefore, we should remember the great people like Gauranga Jena. If you forget, how are you going to continue the good traditions? Amongst Hindus, there is a Shraddha ceremony. Shraddha means what is done with the Shraddha. What is that? We remember our 7 ancestors. Pita, Prapita, Prapitamaha. Like this, we offer oblations, means in Hindu law, says in Sapinda marriages. What is that Sapinda marriage? Read Hindu law by means. He says, the persons to whom the oblations are given in ancestry in the ascending order, that is Sapinda. You cannot marry. And science accords with that. The inbreeding which you will see amongst Parsis, among certain communities in Gadwal region and in the Dravidian region, where they marry sisters' children, and the other progeny is biologically affected. It will not be, because gene difference has to be maintained. There is a famous book by Richard Dawkins, a great evolutionary biologist, which you can see in your Google, Selfish Genes. A very beautifully written book it is. So you have seen in Ramayana the uxorious Dasharatha, who had fallen in immense love with the third wife, Kaikeyi. She said Rama should be sent to forest, and her child should be thrown. Dasharatha lamented, cried, the lady did not yield because she was advised by Manthara. Ill advices attract us more than good advices. In Mahabharata, Krishna advised Duryodhana. Duryodhana, you have got everything. Why at all you want to fight with your brothers? Leave all these vices. Tread the good path. Duryodhana said, Hey Krishna, Janati dharmam, nakame pravruttyaha. Janati adharmam, nakame nivrutyaha. Lord Krishna, you think that I do not understand what is the right path? I know what is the right path, but I cannot tread that path. I know the path which I am treading is not the righteous path, but I cannot quit it either. So beautifully it is written. In fact, certain viceroys and the governor generals who ruled from 1857, after 1857, the year 1757, the War of Plassey, which I have read in our history, between Robert Clive and Sirajuddaulah, that happened on the Plassey warfield when Clive founded the British Empire. Such great warriors, Warren Hastings, William Bentinck, they used to keep, Lord Dalhousie, they used to keep Bhagavad Gita on their head, saying, this teaches us how to rule the Indian masses. Kalidasa's Abhignana Shakuntala, Raghuvansha, how great! In Raghuvansha, Kalidasa advises King Bharata, not that Bharata, another Bharata. Bharata, you can't tax people more than 1/12 of their income, their crop. And how you should recover the tax? So beautiful simile he gives. As the bee will suck the nectar without stinging the petals of the beautiful flowers, that way the king should recover the tax. These are our laws. If you read Henry Maine, Ancient Law, Henry Maine never knew anything about Sanskrit. They were more governed and winnowed away, whisked away by Western thought of Roman law. That will not much help you. At least 2-3 books we have, that Ancient Law by Henry Maine and Ancient Law in India by S.N. Jain, one of the co-authors of M.P. Jain and S.N. Jain in Administrative Law. That will not help you much. Our Swatantriya, what is that? Swatantriya, Swatantra. We should be governed by our own laws that have been generated from the soil of this country. Just Dasharatha told Rama to go to forest, and the advisors, the mantris, told Rama, your father has gone mad. He is fallen in love, madful love with his third wife. Do not follow his verdict. What Rama said? Rama said, Mantri Varya, he is my father, Pitru. So Pitru Vakya Paripalanartha, to follow the Pitru Vakya, the words of my father, I should go. Number one. The second one, the reason is very, very impressive. He said, Rama, I have not been coronated yet. I am only a small praja. Not even Rajakumara. He may be Rajakuvara, because he has shed the blood of Dasharatha. Kausalya Putra says, Dasharatha is our king. And if king's verdict is not followed by his own children, the rule of law will fall down. No subjects will follow. They will say, your own son is not following you, and you want to enforce law against us. What a wrong king you are. That will embarrass the king and the institution of kingship. Therefore, and they said, Rama, just assess whether the king is ethically correct. Rama said, it is not my business. Follow the law. We will see in English law, in Roman law. Let heavens fall down. Follow the law. Rama followed it. There is one instance in Cicero's 12 tables. Lord Julius Cicero, he says, A was accused of killing B, and he was convicted. C was asked by the king to take A and execute him. A, accused, convict. B is deceased. C is the executioner. When C took A to Adhasthana, where he was about to behead him, B came from that side on a horseback. Therefore, C took A and B back to the king. King, you had awarded death penalty to A. What a horrible wrong I would have committed had I put A to death. Then king ordered the execution of all the three. A, because he was convicted for the offense of murder, and the conviction has attained finality. B, he was responsible. C, he convicted him because he violated the verdict of the king. You are bound to execute the verdict. You did not. Therefore, you are liable to be killed. What about B? For B, the answer was, you are responsible for the killing of two innocent persons. Therefore, you should be executed. This is the kind of rule of law. Then see the greatness of our old judges. Compare them. With whom I will not say. During Bajirao Peshwa's regime in Maharashtra, there was one king, one judge, Rama Shastri Prabhune, which Justice Rama Joyce mentions in his legal and constitutional history. Prabhune used to go for walk in the evening. When he was going one day, he saw a lean lady with a pale child and stopped there. He inquired, why you are lean and why child is also lean? She said, Judge Saab, my husband is fighting a battle and he is not able to send money to us. I have sent money. Whether he is in the battlefield or paddy field, husband is bound to maintain wife and children. He issued summons to the soldier. Soldier came and said, Judge Saab, our military general has not paid salary to us at all. How should I pay? We are fighting. We are in the forefront of the war. Then he issued summons to the military general. Military general came and said, Judge Saab, Peshwa has not paid salary to any of the members of the house. Where from I should pay? I only have not got my salary. Then he issued summons to Peshwa, a third-class magistrate of the village, issuing summons to King Peshwa, Bajirao Peshwa. Peshwa did not come. He said, I have appointed this judge. Who is this idiot who violates the royalty? How can he issue summons to me? Then this judge issued arrest warrant against Peshwa. Who should execute it? Peshwa is the king. King is above law. We have seen till Crown Proceedings Act 1947 was passed by English Parliament. King could do no wrong, and therefore his servants could not do any wrong. The servants, whatever tort, breach they commit, they were not liable to the public at all. But here is a judge who issues arrest warrant against the king, and king does not obey. Then he leaves that kingdom. Say, the Arthashastra says, Kautilya's Arthashastra says, where the king does not obey the law, do not see the sunset in that kingdom. He took his wife and one child and came down to Karnataka, from which state I came. If I go on telling how the laws are shaped in this country, there will be, I need at least 10 hours to speak. With this, I know that the judge should know the tolerance of the members of the bar and other members also. Only thing is our Jena Sahib. See what name, beautiful name, Gauranga Jena. And the person who spent, Brother Narsingh was telling me, he used to settle the pleadings so beautifully, impeccably, and never took credit for that. He went on reading the biographies. Reading itself is a great thing. Many books are becoming destitute in the library. Not even a page being turned. It should not happen. Always I have said, this is a land of knowledge and knowledge seekers. I also had said last time, the first article of the Constitution, India, that is Bharat, is a union of states. Bharata, Bha means light, knowledge. Nirata, the land where people are engaged in the acquisition of knowledge. Therefore, 23 universities. So many people came, Fayan, Tunga, Dhaga. So many people came here, and they wrote so great books on our history, our culture. Lastly, Brother Narsingh mentioned about the autobiography of Palkiwala, autobiographical sketch of Palkiwala, written in 1980s. We the people. Turn the first page. Palkiwala has mentioned two great thinkers. One is Frederick Max Muller, the another is Arnold Toynbee. What they have said about this country. They said, if human mind is ever evolved fully under the sun and on the piece of earth, it is India. He writes 50 volumes of Indian history, philosophy, scriptures, sacred books of the East under the heading. 50 volumes, Frederick Max Muller. And Arnold Toynbee, the great historian, who pointed out of 21 great civilizations, 18 have collapsed because of their inner conflicts. The termites had eaten them. 3 remaining. One is the great Indian civilization. Therefore, we should focus on acquisition of knowledge, the object, why at all we want knowledge, how to set right our home, our mohalla, our village, our town, our city, our taluka, district, our state, and our country. Once, the great judge whom I mentioned, Oliver Wendell Holmes, was traveling in a train. The ticket collector came and asked everybody, your ticket, your ticket, your ticket. Oliver Wendell Holmes was searching for his ticket, putting his hands into his pockets. Pockets were not yielding the ticket. He was a bit tense. Then the ticket collector said, Holmes, can we ever imagine that a Supreme Court judge of your stature will travel without a ticket? Kindly be seated. But he was tensed again. Again started putting effort to see where he has misplaced the ticket. Then again the collector said, I have told you, Judge Saab, kindly be at your ease. And Holmes became angry. You fool! I am searching my ticket not for showing it to you, but I want to know where I am going. This happens in many of our lives. This should not happen. Thank you so much.
Thank you, sir, for your warm and insightful words. I once again extend a heartfelt welcome to both our esteemed guests and express my gratitude for gracing this occasion with your presence and wisdom. As we draw the proceedings of this monumentous GAURANGA BEHARI JENA inaugural memorial lecture to a close, I request Mr. Gunjan Jena to kindly deliver the vote of thanks. I'm sorry.
So order is called. Put the vote of thanks before.
I may request the members of the memorial committee kindly present the memento to our chief guest, chief speaker, Honorable Shri Justice Dikshit sir. May I request another member to kindly present the memento to the guest of honor, Honorable Shri Justice V. Narsingh sir. Now may I request another member to kindly present the memento to the President of the Bar, Shri Manoj Kumar Mishra sir.
I'm not doing this.
Now I may request Mr. Gunjan Jena to kindly address the vote of thanks.
Good evening, everyone. My name is Gunjan Jena. It's my privilege to give the vote of thanks on behalf of my mother and the rest of our family on this at this occasion, on the occasion of the inaugural memorial lecture in honor of my father. I would like to begin by thanking our guest of honor, Justice Narsingh, for the very kind words he said about my father and for agreeing to grace this occasion with his presence. And thank you, Justice Shripad, for the very edifying and the beautiful address that you gave us, sir. We are deeply honored that you agreed to deliver the first of this lecture series, and we hope we can only hope that the rest of the following speakers, live up to the standards you have set. Mr. Shri Manoj Kumar Mishra, thank you so much, President of the Bar Association. Thank you, sir. Without your cooperation and the cooperation of the association, we would not have been able to hold this event. We would also like to thank the Bar Association in general for the venue and for hosting the event. Mr. Tripathi, thank you so much for moderating this at such short notice. Mr. Patnaik could not make it due to a personal tragedy. We remember him today. And my deepest gratitude is for everybody who agreed to come here, who took time out of their precious Sundays. I know how precious Sundays are to lawyers, who agreed to come here to remember my father and to honor him today with the rest of us. Thank you so much, everyone. My apologies. We also have a high tea scheduled, and the tea and the snacks are kept outside. Please do partake before you leave. Thank you so much. The lecture stands closed. Thank you so much, everybody.
After hearing you, I realized my brother was not like. He gave a very
No.